Uh, Today in this video we are going to discuss about the jurisprudence. In that we are going to see about the administration of justice. Administration of justice என்பது நீதி வழங்குதல். பொதுவாக இரண்டு வழக்குகளை நீதிமன்றம் சந்திக்கிறது. அதற்கு பொது சிவில் கேஸ் என்று பெயர், இன்னொன்று கிரிமினல் கேஸ் என்று பெயர். சிவில் கேஸ் என்பது ஒருவருடைய உரிமையியல் வழக்கு. ஒருவருக்கு உரிமை பறிபோனால் அதனை நிலைநாட்டுவதற்காக வழக்காடும் என்று சென்றால் அதற்கு சிவில் கேஸ் என்றும், கிரிமினல் கேஸ் என்பது ஒருவருக்கு உடல் ரீதியாக அநீதி இழைக்கப்படும் பொழுது அல்லது அதற்கு கிரிமினல் வழக்காகிறது. அதற்கு தண்டனை என்பதே அதற்கு தண்டனை பெற்று தரப்படுகிறது. எனவே சிவில் அண்ட் கிரிமினல் கேஸை how far the justice rendered in civil law as well as criminal law, that is civil law, Civil Procedures Act, and criminal law is dealt under IPC as well as Criminal Procedure Code. So how far the justice is rendered, civil and criminal justice. There are two kinds of wrongs are committed. One is called civil wrong, and first of all we have to see the why this necessity of administration of justice. So if the administration of justice is not there, then there will be, the society will be under anarchy. The strong man will give all sort of harm to the lean man, and we cannot expect the orderly society. So to establish the orderly society, the administration of justice is required, or it is imminent. Then we have seen there are two types of wrongs. There are two types of justice. One is called civil justice and another is called criminal justice. The difference between civil and criminal justice is the civil justice is the wrong committed on others for the compensation. Say for example, a land may be appropriated, a land may belong to one person, it may be appropriated by another person, for which the remedy is the restitution of property, or compensation. If at all it could not be done, the compensation is given to the aggrieved party. That is the civil wrong. And whenever the criminal justice is given, then the compensation is not the remedy, but the punishment is the remedy, because it is the affectation on the body, or affectation on the prestige, or affectation on property, or violation on the court fee stamp, or these are all coming under criminal case, for which the state government, the government itself takes the law and it is dealt. The justice is rendered by the state. So the public prosecutor take up the argument, and evidences are collected in the criminal scene, and the justice is rendered. But as regards the civil cases, the record evidence and other evidences are taken, and then justice is rendered. That is the and another remedy is, we already told that here is compensation in the form of money, and there the punishment is the remedy, that is jail sentence, or fine plus jail sentence, or both. Then civil wrong. What is Sometimes next thing is wrong resulting in civil and criminal remedies. Some of the wrongs is falling under both criminal justice system and civil justice. Say for example trespass. Trespass is tried in tort act, which is not a written law, but at the same time it is also tried in criminal case, and the punishment is awarded, that is in trespass. So under Indian Penal Code it is taken up for justice, and under tort law it is taken up in civil law. Then another thing is, say for example, contempt of court. It is both a criminal and civil. It can be tried in both civil law and as well as criminal law. Say for example, say section 12(3) of contempt of court specifically stipulates that it can be tried in both civil and criminal cases. And then next, civil wrong. Punitive damages are given to the employer. Proceedings, civil wrongs are the proceedings resulting in the punitive damages given to the employer. And then next thing is, some civil wrongs are more harmful than criminal wrongs. Though generally criminal wrongs are so harmful than the civil wrong, but in some cases even civil wrongs are more harmful than criminal wrongs. Say for example, in Bhopal case leak tragedy, it is, though negligence is the main criteria, that negligence led to criminal, that is the criminal catastrophe, and then there lot of people died due to a gas leak because of methyl isocyanate and all. That gas leak ended with a lot of tragedy. Lot of people died, and then even now the people are suffering due to some infirmity. So this was tried in criminal act also, because it is more severe. Though it is a civil wrong, negligence, it is taken up in criminal case also. Then the purpose of criminal justice, that is punishment, is the main purpose in criminal cases. That is, there are four theories are there. One is called deterrent theory, that is to deter. Deter means you should not do the act again. For that, the deterrence theory is there. From the angle of actual offender and from the angle of potential offender, in these two angles it is seen. That is deterrent theory. It is to deter the criminal from doing further act. That is called deterrent theory. Then preventive theory. So naturally the criminal act has come because to prevent the criminal acts. That is called preventive theory. Then a reformative theory. To reform the person, the punishment is given. That is reformative theory. And then the next one is retribution theory. Retribution means the one for another. That is, if according to Hammurabi in Muslim countries, what they do, hand for hand, teeth for teeth, like that. That is called retribution theory, one for another. And then next is expiation theory. That is the wrongdoer to actual compensation. That is expiation theory. That is some way the compensation is given to the affected person. And then the Indian viewpoint seen through court decisions. Some of the in court decisions we can see. Say for example, in Bhopal case tragedy, whether it is civil case or criminal case or both, this can be seen in some of the court decisions we can see. Then civil justice. How in civil justice usually two things are seen. One is called primary right and another is called sanctioning right. If one right is infringed, it will lead to another right. It will lead to infringement of another right. Say for example, it arises out of violation of another right. If one right is infringed, another violation of right will always be possible. For example, in contract, the contract is to be implemented, that is the primary right. And if the contract is not implemented, then the secondary right of compensation to the that is the affected person is called secondary. So the primary right and the secondary right, sanction and primary and sanctioning right will be the right of right in case of that is infringement in contract. Say, and then the second thing is proceeding petition of rights. In some of the cases, the secondary function of the court of law, second thing, in that we are going to see petition of rights. It is usually there are rights to establish on petition, usually on the state. So what the important thing is 60 days notice should be given in case of taking proceeding against the state. Then declaration of right, declaration of nullity of marriage, these are all coming under declaration of rights. Then administration of say for example administration of right, in case of liquidation of company, a trust is formed. This is in case of administration of right. And title of right and adjudication in case of bankruptcy, that is coming under the title of rights. Then so usually the supervision of lower court is best with the high court under article 227. So the high court is always supervise the act of the lower courts under the article 227 of Indian Constitution Act. Then what is the Indian position in administration of justice? So we will see some important acts. Right to Information Act 2005. So whenever any the rights are not established, whenever an individual right is not established, whether it is a public or it is a person who is employed, then he can seek the right. He can seek the justice under Right to Information Act. That is, he can seek the under what authority this has been done and what is the thing behind an act taken. All these things, the information can be obtained from the concerning authority under the Right to Information Act, for which he has to give petition with 20 rupees stamp, and then what the information is asked they have to give within 30 days. That is under Right to Information Act under 2005. Or otherwise even the punishment is given if not given within 30 days. The information commissioner appointed in the particular department should pay fine for the individual who is applying for RTA. Then Consumer Protection Act 1986. To establish the consumer protection, 1986 has come to handy to protect the consumers. Whenever the rights of the consumer is affected, he can seek the consumer protection authorities, that is the state consumer district forum, consumer state forum, or national consumer protection forum for compensation if is that is the consumer some harm to the done to the consumer. Say for example, a person is purchasing a good from the goods from the shop for consumption, not for sale, but for consumption. If anything goes wrong with that, it has to be compensated. That is consumer. Like that, negligence. If any negligence happens to the consumer, then it should be compensated. Then Industrial Dispute Act 1947. It is between the act to control the employer and employee. Whenever any dislocation happens between employer and employee, that is solved under Industrial Dispute Act 1947. It is through the Industrial Dispute Act, maybe some retrenchment may happen. For that, the under Industrial Dispute Act, one can sue the employer under Industrial Dispute Act. Then Legal Services Authority Act, that is some of the cases are set right through Lok Adalats, which is set up by the government, that is Legal Services Authority Act. And Family Court Act, any family dispute arises, that is settled by Family Court Act. Say for example, that is nullity of marriages, or that is the dissolving of marriage, or maintenance. Such of the cases are taken up in family courts. And the next one is alternate dispute resolution under the Act of 1995. There are, suppose arbitration, conciliation and mediation are held in are held out of court of settlement. So under Arbitration Act, if Arbitration Act is there, with the agreement between two parties, an arbitrator is appointed, and the rights are established amicably between two parties. If at all, because it is between the table under the between two parties, the things are amicably settled with the help of the arbitrator. That is arbitration. Similarly, conciliation is also between employer and employees. Problems are settled between employer and employees. And mediation, a mediator is also appointed by the court, and he mediates the problem between two parties and amicably settled. These are all some alternate dispute resolution under Act 1995. Arbitration and Conciliation Act, that is under Section 10A of India. Under 10A of Industrial Dispute Act, the arbitration and conciliation is made between the employer and employee, if at all there is a problem exists between the employer and employee. So பொதுவாக இந்த அட்மினிஸ்ட்ரேஷன் ஆஃப் ஜஸ்டிஸ் என்பது நீதியை வலியுறுத்துவதற்காக அமைக்கப்பட்டது. இது சிவில் கேஸ், அதாவது பொதுநல உரிமையில் வழக்கு, தண்டனை பெற்றுத்தரும் வழக்கு என்று இரண்டு வகைப்படுகிறது. சிவில் அண்ட் கிரிமினல் கேசஸ் என்று படுகிறது. அதில் எவ்வாறெல்லாம் அந்த கிரிமினல் கேஸ், தட் இஸ் ஐபிசி, இந்தியன் பீனல் கோட், இந்திய தண்டனை சட்டம் எதற்காக இயற்றப்பட்டது என்ற ஒரு தியரிஸ், 4 தியரிகள் இருக்கிறது. இந்த தியரிகள் அடுத்ததாக பிரைமரி அண்ட் சாங்ஷனிங் ரைட்ஸ் ஆஃப் தி பார்ட்டிஸ் என்றால் என்ன என்றெல்லாம் இந்த அட்மினிஸ்ட்ரேஷன் ஆஃப் ஜஸ்டிஸ் பார்த்தோம். வித் திஸ் we conclude this video.